This is a 2014 Supreme Court case, and it deals with DUIs and anonymous tips. The case, Navarette versus California. And if you watch this channel, you already know my name is Antonin Scalia. I'm a criminal defense attorney and a business attorney practicing in the Southern District of California. I recently had a case with very similar facts to this one, and I had to reread Navarette. Here's what Navarette is all about. August 23rd, 2008. 911 dispatch receives a call. Here's the information that's being relayed to the officer. Southbound Highway 1 at mile marker 88, silver Ford pickup F150 is driving southbound. Plate number is 8 David 94925. The reporting party says that the vehicle almost drove her off the road and was last seen approximately 5 minutes before. 13 minutes later, the officer locates the vehicle on the freeway. Only 5 minutes later, he pulls over this vehicle. As the officers approach the vehicle, they smell marijuana. And ultimately, they do find 30 pounds of marijuana in the car. Question: does the stop comply with the Fourth Amendment? And did the officers lack reasonable suspicion to pull over the truck? Under the Fourth Amendment, police needs reasonable and objective basis of suspecting that a particular person is committing a crime. We call this standard reasonable suspicion. Reasonable suspicion also depends on totality of circumstances, the content of the information, and the degree of its reliability. These principles apply for stops that are based on information from anonymous tips as well. From the Supreme Court case Alabama versus White, we know that anonymous tips seldom provide information and seldom provide the basis of knowledge and veracity of the informant. This is because ordinary citizens generally do not provide good information to the cops. They rarely remember it. Of course, a tipster who provides truthful information before will generally be believed by the cops and the court. And if she accurately predicts the future, she will also be believed. In this case, the court deems the caller reliable for a number of reasons. Number one, she accurately describes the vehicle. Number two, she was a victim because the truck almost ran her off the road. Number three, she observed the vehicle firsthand. Number four, police confirmed the location of the vehicle when they pulled it over. She made the statements to police contemporaneous to the events as they were happening. And finally, the fact that she used 911 emergency system seems to be important to the court. The system records the calls and has identifying and tracing features. So people generally do not lie to 911 operators. At least that's what the court says. Given that the caller was reliable, the court says the officer had enough information to pull over this vehicle. In other words, this provided enough reasonable suspicion of drunk driving. Of course, you can roll your eyes now. This case is terrible. You're telling me if the caller identifies a car, makes anonymous claim of a single instance of careless or reckless driving, calls 911, this will support the stop of the vehicle? Justice Scalia wrote a very strong dissent. The fact that the truck ran her off the road neither asserts that the driver was drunk or even raises the likelihood that this person was drunk. She never says anything about drinking and driving. Then for 5 minutes, we have an officer following the vehicle before pulling it over. The driver of the truck drove it perfectly for 5 minutes. And in the famous lines of Justice Scalia, the majority's opinion serves as a freedom-destroying cocktail consisting of two parts. That an anonymous 911 report of traffic violations are reliable as long as they correctly identify the location and the vehicle. And number two, that a single offense of careless or reckless driving necessarily supports reasonable suspicion of drunkenness. I know this case seems very strange. It seems that it almost eliminates the whole reasonable suspicion when it comes to informants and anonymous callers. But this case can be distinguished on its facts. And I will leave you with this question. Does this case apply if the anonymous caller is not a victim? If, for example, the anonymous caller saw you drinking at a party, saw you leave, but never saw you driving, would this case be different than Navarette? If you like this channel, please click subscribe below, and thank you for watching.